Prego.
Bene, buongiorno a tutti i nostri studenti, ai non studenti. Benvenuti a questo seminario che la Scuola di Culture, Politiche e Democrazia, insieme al Dipartimento in Diritto e Società Digitale dell'Università UnitelmaSapienza di Roma, ha voluto organizzare, avendo la grande opportunità oggi di avere qui con noi il professor Daniel Ortiz. Il professor Daniel Ortiz, grazie professore, thank you very much for coming here. Il professor Ortiz è professore di diritto costituzionale alla School of Law dell'Università della Virginia, ha un grande background nel diritto costituzionale, nel diritto amministrativo, nel diritto elettorale, nella teoria giuridica, si è formato a Yale, ad Oxford, dove ha preso il suo dottorato di ricerca e ha fatto il visiting professor in diverse università, tra cui Berkeley in California, e fino allo scorso anno, anzi a quest'anno, poco fa, ha diretto la Supreme Court Litigation Clinic della School of Law dell'Università di Virginia. So thank you very much, Daniel. The seminar will be in English, but before starting with the conference of Professor Ortiz, prima di partire con la conferenza del professor Ortiz, io chiedo al direttore del Dipartimento di portare il saluto del Dipartimento.
Grazie al professor Petrillo. Sono veramente lieto di portare i saluti del Dipartimento di Diritto e Società Digitale, il mio saluto personale a questo evento, a questo interessantissimo seminario. Se me lo consentite, vorrei però anche ringraziare una persona che al momento non è presente, che è il professor Guadagni Gianluca, che è l'amico comune che insegna alla Università della Virginia, alla School of Data Science, che ha reso anche possibile questa iniziativa, e naturalmente ringrazio Dan di aver accettato l'invito del professor Petrillo, che appunto è il nostro punto di riferimento per le questioni che riguardano il tema delle lobby in una prospettiva comparata. Il Dipartimento è una realtà di recente istituzione, ma ha già al proprio attivo numerosissime iniziative e mi sembra che questa iniziativa si collochi in quel livello di qualità, no? Che contraddistingue la nostra attività, con una proiezione sicuramente internazionale, una prospettiva europea e comparata. Il tema è tra i più interessanti, anche in vista delle elezioni che ci saranno il prossimo anno negli Stati Uniti. Io sono uno studioso di diritto dell'Unione Europea e quindi quello che posso sottolineare dalla mia prospettiva è che il 1° novembre è entrata in vigore una modifica al regolamento del Parlamento europeo che recepisce i 14 punti di un piano d'azione della Presidente del Parlamento europeo, che sono stati adottati, una sorta di codice di condotta, che sono stati adottati per dare delle risposte concrete al cosiddetto Qatargate, quindi allo scandalo che ha coinvolto alcuni parlamentari europei e che ha evidenziato anche delle lacune, nella disciplina precedente, in particolare nell'accordo interistituzionale che era stato siglato ed è stato siglato tra la Commissione, il Consiglio e il Parlamento europeo, volto ad istituire un registro per la trasparenza. Il Parlamento europeo si è rivelata forse l'istituzione più vulnerabile sotto questo punto di vista, anche perché occorre considerare che c'è un'esigenza diversa, non direi contrapposta, ma complementare, che è quella di garantire l'esercizio del libero mandato dei parlamentari. Quindi è difficile trovare un punto di sintesi tra una disciplina che appunto obbliga ad un livello di trasparenza sicuramente stringente, dall'altra parte la libertà nell'esercizio del proprio mandato, che viene rivendicata dai singoli deputati. La modifica, diciamo così, introduce dei criteri più restrittivi, cioè un obbligo di iscrizione al registro, un obbligo di pubblicare online le riunioni, che prima invece era solo limitato ai relatori, adesso viene esteso ad una serie, a tutti i deputati, e poi diciamo, fa fronte proprio a quella esigenza di considerare anche i rappresentanti degli stati terzi, che invece non potevano essere considerati quali portatori di interessi, e quindi cerca di colmare queste lacune. Naturalmente anche a tal proposito ci sono state delle critiche, ci saranno giustamente delle critiche, perché secondo alcuni è uno strumento ancora troppo flessibile, ancora troppo debole rispetto a questi fenomeni, secondo invece altri osservatori e studiosi rischia di appunto comprimere quella che è la libertà del mandato dei parlamentari. È sicuramente un dibattito avvincente che a mio avviso mette in luce come ci sia un ambito di espansione di questa disciplina sulle lobby che si va vie più ampliando, quindi toccando anche ambiti che prima non erano forse interessati da una disciplina di questo genere, quindi anche al di là dello svilupparsi del processo legislativo puro e semplice. Quindi non so se colgo il segno, e lo dico da appunto non studioso, ma mi ha colpito molto che il 13 novembre la Corte Suprema degli Stati Uniti si sia dotata di un codice di condotta a tal proposito. Quindi evidentemente diciamo, è un fenomeno che esorbita anche dalle istituzioni che sono attori del processo legislativo, per toccare ambiti anche di natura diversa, ma mi sto addentrando in un terreno non mio, quindi mi fermo sicuramente. Ringrazio per l'attenzione e ho sottratto già troppo tempo al nostro illustrissimo relatore, al quale do di nuovo il benvenuto e vi auguro naturalmente buon lavoro. Grazie.
Grazie mille al Direttore del Dipartimento anche per aver voluto sintetizzare d'altronde da professore ordinario di diritto dell'Unione Europea, quella che è la situazione europea. È molto interessante, su questo ci torneremo poi dopo in fase di discussione, dopo la relazione del professor Ortiz, che illustrerà il sistema di regolazione del lobbying negli Stati Uniti d'America. Poi magari torneremo proprio in fase di dibattito anche con i colleghi Roberto Di Maria e Silvia Sassi, che vedo collegati. Sarà interessante tornare a fare un confronto, proprio una comparazione tra il contesto statunitense e quello europeo. D'altronde i modelli di regolazione sono simili, hanno gli stessi difetti, hanno gli stessi pregi, ma come adesso il professor Ortiz ci dirà, il sistema statunitense, anche perché ha una regolamentazione che risale addirittura al 1946, ha una sua storicità che le giovani istituzioni dell'Unione ancora non hanno. Allora, nel salutare tra l'altro anche i colleghi che sono voluti intervenire qui del Dipartimento e che ringrazio, ai quali sono pronto a cedere la parola appena lo vorranno, anche i colleghi dell'Università Sapienza di Roma qui presenti, e il nostro assenista di ricerca, Tiago Burkhardt. So now I switch in English, and I'm very proud to have today the opportunity to discuss this topic with Professor Dan Ortiz. I give you the floor for your conference. Please, Dan. We have to share also other microphone.
Buongiorno, grazie per il vostro invito. A causa della povertà del mio italiano, a causa del mio accento, atroce americano, parlo in inglese. Mi scusino. Thank you all and very much for showing up for the presentation. Basically, I've spent a few minutes with you all today, going through the basics of lobbying law in America, trying to make some comparisons, although I will leave most of the comparative work to you all since you're more expert on the EU piece of the picture puzzle than I am. So an overview. I hope to give you a little bit of history of lobbying regulation in America, then a description of where we stand now, how much money is spent in lobbying, who is spending it, where it goes, that sort of thing. And then try to talk about some ways of evaluating lobbying normatively. And I imagine that part of the puzzle is pretty much the same here as it is in America. Then I want to dive down into the lobbying rules themselves, explain the regulatory approaches that are taken, and show primarily how the legislative lobbying side of things work. The executive side is a little bit different, but the approaches in structure are broadly similar. Then I want to suggest and make some tentative evaluations. And finally, if we have time, I hope to show how lobbying fits as just one piece of a much larger picture, which you can call the economy of influence. Right, so a little bit of history here. Lobbying, basically the right to lobby, to petition for redress of grievances, started with Magna Carta in England, 1215, when the barons of England rebelled against King John, brought a series of complaints, and in Magna Carta made him agree to respect their rights. Interestingly, the enforcement mechanism was that anyone who felt aggrieved that the king was not abiding by what he had promised could go to a committee of barons and petition them, basically say the king is not playing as he should, and then the barons, if they agreed, would have the right to rebel lawfully against the king and attack his castles, things like that. But originally it wasn't a right in English law to actually petition the government. It was a right to petition those who could rebel against the government to keep the government to its word. Later, in the late Middle Ages, Parliament itself became the petitioner and would write petitions, submit petitions to the king. And this came to a head in 1689 when some bishops tried to petition the king about a religious matter, and the king basically threw them into jail. At which point the courts of England said, no, 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 you can't do that. There is this right called the right to petition, which is sacrosanct, and the king and the government basically have to acknowledge it. In American history, most of the separate colonial legislatures allowed a right to petition. And then, as you will see from the times here, the years that are listed in these various events, around the time of the American Revolution, the right to petition came to a head. The American colonists were very unhappy with what the British government was doing. In 1774, the First Continental Congress sent a petition to the king asking for some acts that were called the Intolerable Acts to be reversed. The king basically ignored it. The next year, 1775, the Continental Congress tried to make peace and sent what's called the Olive Branch Petition to the king, basically saying, well, let's negotiate. The king paid that no attention, partly because the day after, I believe it was the day after, maybe it was the week after, the Continental Congress sent the Olive Branch Petition to the king. They declared that it was necessary to take up arms against the English king. And so that pretty much started things on a very bad path. And the next year, we got the Declaration of Independence, which itself is a kind of form of petition of grievances to the king. Now, In early national history, the First Amendment to our Constitution, which is very important still today, contains what is known as the petition clause, which is the bit in green here. It's sort of hard grammatically to see, so I've tried to highlight the bits that make it relevant. But it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably to assemble and to petition the government for redress of grievances. And it's this last clause, the right to petition, where people nowadays locate the constitutional source of regulation and limits on regulation of lobbying. In our early national history, petitioning and lobbying was fairly common. It was subject to very formal requirements, so Congress required that petitions be submitted in a particular form, which we sort of see in the picture on the left. Then, in the early 19th century, a former president, John Quincy Adams, who was very much against slavery, saw that petitions could be a very effective means to embarrass the southern states where slavery was still practiced. And so he basically encouraged people across the country, and largely people who were enslaved or had been enslaved, to submit petitions to the United States Congress. And this became so intolerable to the southern states that they imposed what was known as a gag rule, said that Congress will not entertain any of these petitions. And this was seen as, after about 10, 15 years, it's very contentious. Congress itself, as we got close to the American Civil War, decided that it was unconstitutional because of the petition clause in the First Amendment. Very quickly, though, petitioning fell into some disuse. It was one way, people had the right to submit petitions, but after that, Congress didn't have to do anything with them. So typically people would write things up, make complaints, send them in, and then nothing would happen. So the right was formally preserved, but in effect, it didn't really mean very much at all. Now, the modern history and debate is a little bit more easily understood. Yeah, for most of the 19th and early 20th century, the big concerns about lobbying were not constitutional, but just whether lobbying contracts were enforceable or not. And this was a matter of state law, not national law. And many states took the position that there was something uncomfortable about lobbying, and that many of these contracts where you would hire a professional to represent you rather than representing yourself were against public policy, and so they were unenforceable. As a result, if you hired a lawyer, say, to represent you, to write up a petition and speak to people in Congress, people found you didn't have to pay your lawyer because the employment contract itself was unenforceable under law. Then in 1946, Congress entered the picture for the first time and passed the Federal Regulation of Lobbying Act, which was, I'm happy to answer questions about it, but because of the way it was interpreted by courts against the background of the First Amendment, did not actually do much at all. And there were a few very high-flying scandals in the 1980s and the early 1990s, and Congress was pressured to revisit this area, and in 1995 passed the Lobbying Disclosure Act during the Clinton administration. That still left room for some various scandals. In 2007, Congress passed the Honest Leadership and Open Government Act. And that's pretty much where we are now in the federal system. Of course, in America, each state has its own law. Some of them have fairly strict and comprehensive lobbying laws, like California. Other states have very minimal ones. So the situation just varies from wherever you are in the country. So if you wanted to describe the arc of history in this area very generally, you'd say that 2 centuries ago it was mostly individual people who were lobbying. Now it seems to be mostly businesses who are doing most lobbying, and the ones spending most of the money, as we'll see. It's become a professionalized activity, mostly run by lawyers, management consultants, media consultants, people like that. Very few people, apart from people complaining about their taxes or something like that, would bother sending in letters about individual matters to Congress. And there is an increasing ambivalence about it as businesses have become the major players and it's become increasingly professional. At the very beginning, 2 centuries ago, it was seen as a core American individual right. And now people are worried that, well, this is just a way for businesses to gain more political power. So people are very uncomfortable with it. So let me give you some facts on the ground just to describe what the picture looks like these days. We'll talk about total spending on lobbying, which interest groups are spending, who the largest individual spenders are, the number of lobbyists who are employed, and I'll make some comparisons, but I want to the EU. But I want to suggest the comparisons are very difficult and probably not very meaningful. So be careful what you take away from them. So first here you have a graph of lobbying spending from 1998 to 2022. And this is in billions of US dollars. That's right. So you see at the end there, you're pushing close to $4 billion. It's gone up and up and up. But you'll notice that sometimes it's plateaued and been flat for a while. And there may be some interesting stories there that you can understand if you know a little bit about American history. So if you look from, say, before 2000, it was fairly flat. In 2000, we had a major presidential election. You probably remember Bush versus Gore. The Clinton administration, which was Democratic, had been in power for 8 years before that. 2000, very contentious, came down to basically a vote in Florida. Lots of litigation before the Supreme Court, lots of unhappiness. Nothing compared to 2020, however. No marches on the halls of Congress. George Bush was declared president ultimately. And he was president from 2000 to 2008. So you see a large rise during that administration. 2008 was also the beginning of the financial crisis. So that may explain some of the failure to expand after that. But from 2008 to 2016, you have the Obama administration, 2 terms, during which the expenditures were fairly flat. Probably some of that reflects Democrat versus Republican administrations. Probably part of it reflects the financial crisis. It's hard to say. And then in 2016, you have the election of President Trump, again, the Republican president, and lobbying starts going up again. 2020, you have the Biden administration. It seems to still be going up. But there's an awful lot of spending during the Biden administration because of COVID and other things. And whenever federal government spending goes up by a lot, you would not be surprised to see an increase in lobbying activity, just because there's more to go for, if you will. So here are the major interest groups, if you will, in terms of spending. And these figures are millions of US dollars. So by far, as you can see from the graph, the major interest group spending on lobbying are pharmaceuticals and health products, drug companies, hospital corporations, that sort of thing. Second would be electronics manufacturing equipment, basically the internet industry. Third is insurance. Fourth, securities, and basically these are all financial. Then you have real estate, which surprises some people because real estate is mostly regulated on the state level, not the federal level. But there are some very important issues, just a few of them, to the real estate industry on the federal level, in particular what's known as the federal mortgage interest deduction, which comes to taxes, which is very important to that industry. Business associations, hospitals, home, energy, you see there, again, a different aspect of health care. Then you start seeing things like air transport and various other stuff, and then civil servants and public officials, public unions. Then if these are the individual spenders, those are by industry. These are the individual organizations spending in 2022, not so long ago. The first that year was the National Association of Realtors. Second was the U.S. Chamber of Commerce, which is a group that represents large businesses in America. The National Association of Realtors came out a little bit ahead. This year, it seems that just the reverse. The U.S. Chamber of Commerce seems to be a little bit ahead. Then comes what's known as Big Pharma, the drug industry. Then the American Hospital Association, Blue Cross Blue Shield, which is a big insurance outfit. Then what was then known as Facebook, now Meta. More healthcare, Amazon. You start seeing the internet industries becoming large players. That was not true 10 years before. They were not spending money really at all on lobbying. And then towards the end, you see Lockheed Martin, Boeing, which are, of course, big defense contractors. So that's a big chunk of the federal budget. So it's just another graph, number of registered lobbyists in the United States from year 2000 to 2022. You see that it's not really changed very much. And I want to suggest that that's largely because how the lobbyists are defined and how, because of the definition, the lobbying industry is structured, but we will get to that. So, for example, here's a cross comparison between the EU and the U.S. You'll see that officially, if you look at the number of people who are registered in the EU Transparency Register, they're basically the same as the number of lobbyists in America on the federal level. That seems quite surprising. Right? You have, for example, the amount of money spent, though, is quite different. About twice as much in the U.S. as in the EU, which is very surprising when you consider how different the budgets are. The EU budget is about 200 billion euros, whereas in the US it's 1,400 euros. And so given how much more is at stake just in pure budgetary terms, in America, the rough equivalence of the number of lobbyists, and even just the fact that twice as much money is spent, seems a little bit surprising. I want to suggest that people shouldn't take away too much from that because the comparisons here are very difficult. You have different governmental competencies between the EU government and the United States federal national government. Different subnational competencies. It's very complicated, of course. Most important, perhaps, you have different definitions of lobbying and lobbyists. And I believe that that's driving a lot of the difference here. And then finally, I think each lobbying is just one part of a bigger picture, and those bigger pictures are very different in the EU and America. So the background in which lobbying occurs is different, and it should be unsurprising, I think, that in that case, lobbying itself should look a little bit different. So before we start looking at American lobbying law and the controlling statutes, just want to talk a little bit about how to evaluate lobbying. And it may be the EU perspective is a little bit different. I suspect that it's somewhat similar. So on the one hand, you have this debate. People say that lobbying is good because it leads to better informed decisions. Those people who are about to be regulated have better access to the information that is necessary in which to make the decisions about how you should regulate, that sort of thing. And so if you don't allow them to bring concerns to the legislature or to the executive, you're going to have substantively worse decision making. And it's very important to get things right, or at least as good as you can. On the other hand, people will say that there is a very big danger of regulatory capture, where the interests that are being regulated actually capture the regulators, in part through the ways they feed them information. And people point out that just as they can transmit good information, accurate information to regulators, they can also deceive regulators if they want. And in America, probably the best example of this would be the tobacco industry, which for years and years and years knew that smoking caused cancer, but insisted the opposite. Second, more in terms of democratic theory, You have people who say lobbying is good because it allows for fuller representation. If anyone can come and bring concerns before the political decision makers, that's democratically a plus. On the other hand, people will say that may be true, people can come, but that representation is going to come at the price of inequality. Some people, especially or interests, especially ones that are concentrated and have a lot of money, are going to carry more weight and are going to be able to more effectively lobby than other people. And therefore, although it may be democratic in a sense, it's going to be unequal, which is also an important aspect of democracy. Okay, so now we want to get into the rules so you can see how all this works on the ground. I'm not talking in complete abstractions, but some cautions before we jump too far in. First, I'm going to be talking only about the federal system and not the state system, and say each state is very different. And really, we're only going to be talking about one part of the federal system, which is the legislative lobbying, not executive lobbying or other forms of it. Different branches in the federal system have somewhat different rules, although the structure of regulation is broadly similar. We're not going to be talking about judicial lobbying at all. There is a hodgepodge, meaning just a mess, of controlling legal authorities and various regulatory approaches, especially if we talk about the whole country as a whole, including the states. And of course, as in any place, there's the issue of law on the books versus the law in action, and how whether you might have one set of laws on the books that looks like it operates one way, but is enforced or not enforced, quite differently. And so that really matters. And then we want to talk about lobbying's place in the larger ecosystem of influence. So the legal authorities, we've talked mostly already about the Constitution. And there is not much constitutional law on the right to petition or the right to lobby. I argued, I think it was the last right to petition clause case before the Supreme Court, and that was about 15 years ago. Now, it's just something that doesn't really come up very much. Most of the action happens around statutes, executive orders, which are orders of the president, basically laying out commands that apply within the executive branch, administrative regulations, which are rules that individual agencies pass regulating lobbying for them. And then of increasing importance over the last 30 years have been congressional rules, where each House of Congress makes its own rules about access to legislators. And then, of course, there's going to be judicial law, what the judges say under all of these things. So the major things we'll be talking about today, and this is where most of the action is at, is the Lobbying Disclosure Act, which was passed in 1995, and the Honest Leadership and Open Government Act, HLOGA, which was passed in 2007, to basically fix some things that people realized were still problems after the enactment of the Lobbying Disclosure Act. But these are the two that we're going to spend most time talking about today. So how does the Lobbying Disclosure Act work? Structure is pretty easy to talk about, and I think it's more helpful to actually see the schematic, which this comes from Congress itself, rather than parse through each of the statutes. But when a lobbyist enters into agreement with a client, that person is supposed to, within 45 days, file what's known as a Lobbying Disclosure Form 1, an LD1, with both the Secretary of the Senate and the Clerk of the House. So these are the two officials, one for each House of Congress, who are in charge of accepting the registrations. Okay. Then after in that registration, you'll say, so-and-so has hired me to basically lobby on their behalf on these sets of questions. Then every quarter, so 4 times a year, you have to file an LD2, which basically says how much money you have spent for each client during that quarter lobbying Congress and on what questions. You do not have to say which individuals in Congress you contacted, which people, Congress people or congressional staff, but just how much in general you spent and what the issues were that you spent it on. Then twice a year, and this is new from the HLOGA Act in 2007, you have to file a lobbying disclosure to 203, which discloses certain political contributions that you have made on behalf of campaign committees, people who are in Congress. Now, lobbyists or lobbying firms which do not comply with these requirements will be notified by the Secretary of the Senate or the Clerk of the House that they're not in compliance. And if they don't come into compliance after a certain amount of time, the Secretary of the Senate or the Clerk of the House can refer them for criminal prosecution to the United States Attorney's Office for the District of Columbia. There really aren't many criminal prosecutions. If people are found by the Congress to be, if lobbyists are found not to be in compliance, they typically come into compliance. The real problem is whether the Secretary of the Senate and the Clerk of the House are offices that are notoriously understaffed, how much policing they can realistically do themselves. But realistically, there is not much criminal prosecution. There is only criminal prosecution if there's another criminal charge being brought here. So some questions. So who counts as a lobbyist? What counts as a lobbying contact? Which government officials are covered? Like, you can't imagine covering every government official. It just gets to be too complicated. You want to aim the regulation at those people who count most, so you get the biggest bang for the buck. And what counts as a lobbying activity? These are the four major questions under the Lobbying Disclosure Act. And you can see them here in the schematic. So the first stage is, who counts as a lobbyist. The second day is making lobbying contacts, right? You have to register, report, have lobbying contacts. The quarterly report concerns lobbying activities, right? So these are all different. Things, and each one becomes relevant at a slightly different part of the process. This is actually a book that you can buy in America on Amazon.com, maybe in Italy too, if you want, and you're thinking of becoming a professional lobbyist. But who is a lobbyist? So there's a two-part test, and you have to satisfy both parts. First is someone who makes a lobbying contact in representing a particular client, and we'll talk next slide what a lobbying contact is. But you basically have to make more than one, so 2 lobbying contacts for an individual client. And you have to spend more than 20% of your time on lobbying, so-called lobbying activities. Not for that one client, but just lobbying activities in general. So you have to be working on behalf of someone. You have to you have to reach out in a particular way at least twice. And more than 20% of all your professional time has to be spent representing this type of person in these kinds of activities. If you don't satisfy one part of the test, you're not considered a lobbyist. So much of this comes down to what constitutes a lobbying contact. So it's a communication, could be oral, could be written, to a quote unquote covered legislative or executive official. Not everyone counts. So for example, if you contact, say, the custodial staff at the U.S. Capitol, that doesn't count. Custodial staff are not covered. It has to be on behalf of a particular client. And then the concerning, and this is where much gets done, very important, the formulation, modification, or adoption of a federal legislation, or the second subclause, same as to executive action. Third, administrative action, or the making of a grant or a contract, that sort of thing, or the nomination of anyone who requires Senate confirmation. So lobbying on behalf of a Supreme Court nomination. Supreme Court justices in our country have to be approved by the Senate. So they're groups of lobby on behalf of particular nominees and against particular nominees. And those people, that counts as a lobbying contact. Now notice that the fourth clause is very capacious, covers an awful lot: the formulation, modification, or adoption of federal legislation. Very broad, almost anything. So much of the limitation is done by who is covered by it. So on the legislative side, any elected legislator counts as a covered official. So if I am working on behalf of someone and I reach out to someone who has been elected to Congress, that counts as a legislative contact. Anyone elected by those people to help run Congress, like the clerk of the House, the secretary of the Senate, those officials, that person is covered as well. And then all the employees of those people and congressional committees and other official congressional groups, caucuses, things like that, those people are covered as well, as well as other specific legislative employees whose positions require them to file regular public disclosure forms. So as a result, in Congress, lots of people are covered, and there's a fairly narrow category of people who are not covered. On the executive side, it's somewhat different. The president and the vice president, of course, are covered. Officers and employees of the executive office of the president, those people who are in the White House pretty much. Other high-level employees, and this is determined by the official classification on their employment schedule. So people who are in policy-making positions mostly. And then high-level members of the uniformed services, United States military as well. But in general, the picture is very different. On the executive side, their policy-making positions at the top are covered, but there's a much larger category of executive employees who are not covered. And I can reach out to them without any problem. So, what counts as a lobbying activity? Under the law, lobbying activity means lobbying contacts and efforts in support of such contacts. So that's the big difference. It's not just the individual reaching out to, say, a member of Congress or a congressional staff member, but all the efforts around that are included, including the research around the issues that you want to talk about. So if I'm approaching someone on tax policy, all the research that my paralegals would do, non-lawyers might do about, and economists might do about the ramifications of particular tax policies, that would count, as well as other kinds of things. So if you might want to think of it as a spearhead, the lobbyist is supported by many, many, many other people who do many, many, many other things. And lobbying contact activities is the umbrella which covers all of that. But the actual lobbying contacts are only what the reaching out that the individual lobbyist does to people on the Hill or in the executive branch. So the lobbying law, in a way, covers both, but it covers them a little bit differently. Now, of course, you have the general rule, but as you saw, the general coverage is very capacious. It seems like it covers the whole world. And that's pretty unworkable and really not, it's not, there are a lot of things that happen that really aren't that important. So there are lots of exceptions. I'm just going to cover a few. If I want to set up just an appointment with someone, there's no real talk about policy involved. It's just, can I come to your office and see you? Yeah, what time? 10:30? Fine. Okay, it's sort of purely procedural. That doesn't count as a contact. The subsequent meeting would, but that just setting up the appointment doesn't. A call to say, where's this bill stand? Has it been passed? Is it going to be getting committee hearing? Is it not? That doesn't count. Any information that the government requires. So if the government requires me as a member of industry, say a representative of industry, to submit a report, submitting that report doesn't count. Anything that's inherently public. So if I testify before a public, for a congressional committee, or I make comments on a public record before an agency, that doesn't count. And the idea is that all those things are in the public, people can respond to them, no real problem. There are also some sorts of private communications where the law says that you have a right to privacy and you don't have to disclose them. Those things are not covered as well. But I thought just for fun, I'm sorry, this particular form did not come out well, you might actually see what a lobbying report looks like. This is the quarterly report where you have to disclose the extent of your lobbying activities. This is one from a few years ago by the Coca-Cola company, okay? So you have a company, Coca-Cola company. You have the name of the lobbyist who is submitting it, Mr. Ryan Guthrie. Phone number, And then you see, and this is where the important part of the report is, in the lower right-hand corner, the amount of money spent that quarter lobbying, $800,000. Okay, a lot for just one company, you think. On the second page, you have to list what you were lobbying about, not whom you reached out to in particular, but what you were concerned with. And here, Coca-Cola was reaching out to people about the United States policy regarding foreign implementation of digital taxes and 301 retaliatory tariffs. I think that's trade policy. And then the names of the people who were hired or who were responsible for the reaching out. And then if you were lobbying over something else, you have to list that as well. So here, this is for the Drive Safe Act. They were lobbying over all provisions, including related to apprenticeship programs. And I take it, I don't know anything about what this act was about. It's probably Coca-Cola spends a lot of money delivering Coke bottles to people, to stores. And apparently, I imagine that it's easier for them if they can hire their potential employment pool for truck drivers is larger, and there are some federal restrictions on who can drive a really big truck, as you imagine there should be. And so they're probably lobbying over that, trying to get the pool expanded, so you have more people eligible to drive their trucks. Just guessing, though. Okay, so that's, for one quarter, that's what they were concerned about. And then they have to make a disclosure about whether they were lobbying for foreign entities, as there's a special concern about that. And then finally, they have to disclose any criminal convictions that they've had. And the idea is that we don't want felons lobbying Congress. You might say that's because felons are intrinsically bad people, untrustworthy people, perhaps. Or you might say that Congress is embarrassed to be seen talking to people who have been convicted of crimes, which probably better explains the disclosure requirement. Okay, so that's how the basic picture works. Then in 2007, in response to some scandals, Congress was pressured to strengthen the regulation and enacted the Honest Leadership and Open Government Act. And it aimed to strengthen the Lobbying Disclosure Act by requiring another set of disclosures twice a year of political contributions and payments. So not ones of lobbying people, but of contributing to the campaigns of people who are running for Congress, basically. And certification of compliance that they have complied with congressional travel and gift rules, because people were basically circumventing some of the lobbying restrictions and disclosure requirements by giving people in Congress gifts or staff gifts, or allowing them to travel to very fancy places without having to pay for it. Now, so the first part here is just the disclosure regime. And they have to disclose what political contributions they made. There's a separate act called the Federal Election Campaign Act, which regulates when and how much people can, particular corporations, can contribute to congressional races. But then the second part works a little bit differently, because the travel and gift rules are established by each House of Congress. The Senate has its rules, and the House of Representatives has its own rules. And they're independent, although pretty similar. And whenever one House of Congress changes those rules, the lobbyist now has to certify that they are complying with the new rules. So the law, in a sense, is dynamic, and it keeps up with whatever requirements the particular House of Congress has passed. And by merely sending in the report and electronically checking the one box, a lobbyist is making him or herself liable for violations of any of the internal rules surrounding travels and gifts that the houses of Congress have passed. So we're going to talk, this is what this form, the twice yearly form, looks like. So again, you have the Coca-Cola company. I'm not picking on Coca-Cola. It's just very easy to find their form online. And they give the name of their political action committee. So Coca-Cola company itself is not allowed to give money directly to any political campaign. But Coca-Cola Company is allowed to establish a so-called political action committee, which can contribute to political campaigns. And the Coca-Cola Company can fund all the expenses, not the contributions, the money's in, but all the administrative expenses of the political action committee and the fundraising expenses of the political action committee. And so you think, well, where does the political action committee get the money that it in turn gives to people who are running for Congress? And they can the political action committee can get money from any employee of the company, and high-level employees give a lot, to any shareholder of the company, and to certain other people who are affiliated with the company. So Coca-Cola the employees of Coca-Cola, especially the higher level ones, routinely contribute money to Coca-Cola's political nonpartisan committee for good government. That's the official name. It's actually Political Action Committee. And the money it collects, the committee then decides to give to individual people who are running to Congress. And you wouldn't be surprised to find out that those people are those are the people in Congress who are most important to Coca-Cola's interests. They're typically on the committees that concern policies that Coca-Cola is more concerned about. So, for example, banks would tend to contribute to many members of the finance committees, tax committees, things like that. And so here, the Coca-Cola Political Action Committee contributed to Loudermilk for Congress, which is the fundraising committee for Representative Barry Dean Loudermilk, and to Buddy Carter for Congress, which is the committee for Earl L.B. Carter. Right? Now, if you're an employee of Coca-Cola, supposedly anything you do is voluntary, right? The company is applying no pressure on you to cough up money. High-level employees, though, sometimes feel like they're being shaken down by the company and squeezed to give these monies. And it's a very fine line, how much pressure the corporation can exert, especially on its high-level employees. This is basically the form that they submit. On and on and on for everyone here. And then you will see the certification, number 8, at the end, where the lobbyist says, I certify that I've read and am familiar with the revisions of the standing rules of the Senate and the standing rules of the House of Representatives concerning the provision of gifts and travels. So this is the electronic checkoff that makes the lobbyist criminally responsible, potentially criminally responsible for a violation of the travel and gift rules, whatever they happen to be in Congress at the time. Okay. Of course, enforcement is a big question here. If you don't enforce rules, they don't really matter. It's thought that, like all rules, they're at least somewhat under-enforced. Some people believe that they are dramatically under-enforced. And so what happens is that the law says whoever knowingly fails, so the standard is knowingly, if you just negligently do it, you're not criminally responsible. To correct a defective filing within 60 days after the Secretary of the Senate or the Clerk of the House tells you, and they may never get around to noticing that you failed to do something that you should, or to comply with any other provision of the Act, may be subject to a civil fine of not more than $200,000. And then if you knowingly and corruptly, it's a higher standard of intelligence, fail to comply with the provision of the Act, you can be fined for more money or even imprisoned for it. Very few cases of prosecution under this. So, yes, much of the action here is what counts as a gift and what counts as a prohibited travel expenditure. So we'll be talking mostly about the Senate rules here. The term gift means gratuity, favor, discount, entertainment, hospitality, loan. Again, pretty comprehensive, right? Seems to be covering the whole territory. And the term includes gifts of services, training, transportation, lodging, and meals, whether provided in kind, by purchase of a ticket, etc. So it appears the first step is that basically covers everything of value that could be potentially of value to someone. Now, the techniques of gift and travel regulation, basically two. One, there's some outright prohibitions. Can't do this, can't do that. And then there are certain kinds of things that are permitted, but you have to disclose. They work hand in hand. The rules are incredibly complex. And there are lawyers in Washington who make much of their career out of navigating these rules or people. And for example, gifts to family members of the legislature count, but only if the legislator knows about the gift, doesn't ask the family member to return it, and has reason to believe that the family member was given the gift because of the legislator's official position. It can be sort of hard to prove, right? And there are over 20 exceptions to these very broad rules, some of which people call loopholes, meaning they're not really reasonable exceptions, they're ways to get around the law. So you have this law that appears to reach almost everything, and then you have a series of exceptions to it, some of which make a lot of sense, some of which maybe don't. So some sample exceptions here, okay? Gifts from family and friends don't matter if they're for no more than $250. So my personal friends can give me a birthday present if I'm in Congress, so long as it's not too expensive. Personal hospitality, if someone invites me out to dinner, is fine, so long as it doesn't come from a lobbyist or a foreign agent. Anyone can contribute under the legal restrictions to my reelection campaign. Certain widely attended and charity events don't count, so they're more than, I think it's 25 people on the Senate side, and they're sort of open, lots of, there aren't restrict requirements. There's only one real, or 25 people from one organization coming, that's okay. And then quote unquote, non-meal food is fine too. So there are these rules about cold breakfast is perhaps okay, as long as you're eating it standing up. Donuts are okay. Finger food, things you have to eat, you can eat with your fingers, okay. Toothpicks, pushing it much a little bit, no, but toothpicks eventually are okay. But if it requires a knife and fork, no way. You can't have that. That is absolutely prohibited. So I have another friend in Washington who specializes in election law, and he tells me that he spends some amount of time reviewing menus at these events to make sure that no one gets in trouble. And the reason for that is that the people in Congress who do all this have announced that they don't want to see menus. But people want to make sure they're not violating the law, so they have to send them someplace. They hire a lawyer to basically approve them. More exceptional market value transactions pose no difficulty. Deals that are open to the complete public, no problem. Lottery tickets and other random drawings are fine. Authorized gifts from foreign governments. So if the foreign government is giving me an award, that's okay, as long as it's authorized ahead of time. Certain informational materials, training, that's fine. T-shirts, that sort of thing, fine too. Commemoratives, like a plaque commemorating an event, especially even if it has my picture on it, because something I did. Low value things from your home state. So I come from the state of Virginia, which for centuries has a large peanut industry. So if I'm in Congress and some farmers bring me peanuts, I can accept those without any problem. And presumably I'll use them to promote the peanut industry in Congress. Does not work for if I'm a congressman from New York and the stock exchange tries to bring me shares of stocks. That's going beyond. Pensions, inheritances, no problem. And ethics, these rules are so so comprehensive that technically things like wedding gifts and baby gifts, as you see here in the picture with the little Pope, would be covered. But the law allows me to seek an individual waiver from the committee that controls all this stuff. And then as you can imagine, things get pretty silly pretty fast, and there's some uncertainty. So the lawyers have come before the ethics committees and asked, well, like, not everyone likes donuts. Will croissants fit under the donut exemption and things like that? So it gets ridiculous after a point. Travel, I'm not going to get into too much. It's a matter of unbelievable complexity. And I'll just show you, this is the official congressional guidance now, which says that whether travel is permitted, and you can be reimbursed for it, how it has to be reported, depends upon who's sponsoring it, So this goes on, right? Different rules for different sponsors. It depends upon its purpose, whether it's official or can be unofficial. Depends upon how long the travel is, 1 day, 3 days, 7 days, whether it's domestic travel, whether it's international travel, whether there's a lobbyist along for the trip or not, whether you have to get committee approval in advance or not, and what kind of post-travel reporting you have to do. I'm not going to go through the rules, but just the chart itself, and comes from the Senate Ethics Committee, shows you how complicated it is. The idea is, if you didn't have any kind of regulation of it, lobbyists would basically reward politicians and staff by sending them on free trips to wonderful locations, either places like Italy, maybe Hawaii if you're going domestic, and that people are responsive in bad ways to those kind of incentives. So there's one more regulatory technique we should talk about here, and I don't actually know what the rule is in the EU or in Italy. But ordinarily in America, business expenses, so if I'm a corporation, say the Coke Corporation, and I invest in a piece of new equipment, I can deduct from my taxes that expense. It's a necessary expense for making the product. Right? But I can't actually deduct any lobbying expense. So some people, if you're a corporation, you're going to complain that this is unfair because you're treating lobbying, which is a business expense, unlike every other kind of business expense. If you're on the other side of it, however, and you worry about lobbying, you're going to say, no. All this means is that we're not giving lobbying a tax subsidy. We're just saying that the government isn't paying part of the cost of lobbying by granting a tax exemption, partial tax exemption to it. And this is the actual provision. It says no deduction shall be allowed for any amount incurred in influencing legislation, intervening in politics, or so-called grassroots. But the subsection C is grassroots lobbying, which is lobbying the general public to in turn pressure their legislators to take a particular position on things, or communicating with executive branch officials. Now, it's thought, and for a long time has been thought, that foreign agent lobbying is of particular concern. And so since World War II, in response to lobbying by German interests, Congress has passed special provisions regulating foreign agents. And the Foreign Agents Registration Act requires these people to register with the Department of Justice. These are the people who prosecute the criminals. By regular registration, regular reporting, anyone who serves as an agent of a foreign principal. Now notice foreign principal covers not only sovereigns, the governments themselves, but all foreign political parties, but also any foreign businesses. They're covered here too. One of the exceptions, though, is that anyone who's registered under the Lobbying Disclosure Act doesn't have to register under this. And what that effectively means, since foreign businesses, people lobbying for foreign businesses can register under the Lobbying Disclosure Act, they don't have to register under the Foreign Agents Registration Act. It's only people effectively who are lobbying on behalf of a foreign sovereign or a foreign political party who have to do so. And that's one exception I talked about. The other exception is if you're a lawyer, even if you're representing a foreign sovereign, you don't have to register if you're representing them in just a judicial proceeding. And you also don't have to register if you are just involved in private, non-political commercial activities. So there's a lot more to lobbying law, which we're not going to discuss. We just don't have any time. I probably transgressed already. I apologize for that. There are executive branch rules, of course. There's special rules for nonprofits, special rules regulating antitrust settlement negotiations, special rules regulating people who are getting federal funds, people who are supplying products to the federal government, so-called political intelligence rules for people who are trying to contact the government to get information about what agencies are thinking of doing so they can buy the right stocks or something like that, so-called pay-to-play rules, and the revolving door rule. So someone can't work for the government and then immediately go out and become a lobbyist, typically. They sometimes have to wait. Now, sort of how does all this look and how do you evaluate it? So I want to say this is the public image and this is what the sort of official story you often hear about lobbying. So first I'd look at things you might want to worry about. Not completely adequate, but fairly adequate. There's probably some gaps, some things we still need to worry about. It's a nice sort of mix of prohibition techniques and disclosure techniques. It's evolved over time to address changing circumstances and to things that need to be regulated we didn't realize before. And it strikes, people say, a sensible balance between democratic access and informed decision-making on the one hand, and the worry about capture and corruption on the other. Okay. Some people, though, say, no, that's just the public picture, okay? It's really a wolf in sheep's clothing, if you will, okay? So it's a sort of patchwork of overlapping regulatory authorities. It's unduly complex, and that's perhaps its problem, purpose. If you make something very complex, of course, people can run afoul of it, but also it's harder sometimes to police and to enforce. Some parts of it, some people have charged are purposely designed for regulatory failure. So the Secretary of the Senate and the Clerk of the House are understaffed. And so it's thought that they're really not going to catch many people who are failing to disclose and register as they should. Other people say that it addresses the political optics of corruption rather than what's a real problem. So that there's a scandal, Congress reacts to it saying, no, we won't do that again. But it doesn't really get at the real problems. It's just to make things look to the public like they're being taken care of rather than whether the real worries are addressed. And it ignores the larger economy of influence, of which lobbying is only one part. So we can talk as much as we want, and we can focus on lobbying, but if we don't focus on the larger picture of which it is a part, maybe we're really missing what's most important. And so I want to talk just for a moment about that larger picture. And so you all are familiar, I'm sure, with the economic concepts of substitutes and complements. Substitutes are, economic substitutes are things like tea and coffee, where I might do one or I might do the other, right? But I'm probably not going to do both. I don't want both tea and coffee. Complements, on the other hand, are things that come together, typically, pasta and pasta sauce, right? You're not going to have one really without the other. It doesn't make much sense. But something can be both a substitute and a complement sometimes. I want to suggest that lobbying falls into that category. Also, when you're evaluating influence, you want to talk about, from a lobbyist perspective, you want to talk about its efficiency and cost. If there are other means of influencing, when do you go the lobbying route, and when do you go a different route? And I want to suggest that that depends upon how expensive one route is relative to another, and how efficient the different routes would be. And to do that, you have to look at lobbying adjacent activities, all the things that happen around lobbying. And finally, I want to suggest to you that in this larger picture, everything is hydraulic. And by that, I mean it's like a water balloon or an air balloon. If you squeeze in one place, the pressure builds and it extends in others. You don't get rid of the problem there. You largely just displace it. And it often will distort the rest of the picture. So we're just going to look at one thing very quickly. So, how do you, if you want to influence someone, how might you do it? You can just directly pay them money, right? That can be pretty effective unless you're caught. So what we've done there is, because it's so efficient, right? If we didn't have any rules against bribery, presumably people would do it. They still do it, even though it's a crime. So what we do is we raise the cost of that way of influencing people by threatening them with jail time, fines, things like that. You could indirectly pay people by giving them gifts or fancy travel or something like that. So we have to regulate that. You could give them a job now or later for possibly no work. And I know this happens in Italy as well as America. You could give a family member a job under the same kinds of terms. You could contribute to the person's favorite charity, perhaps a charity named after them. Or you could contribute to their campaign fund or party. So all of these are different ways. Compared to the last, you could talk to them, right? Maybe even persuade them on the merits of something, what we like to think of as lobbying, or the purest form of lobbying. But there are all these other ways you could do it too, some of which, if they were not regulated, you would think would be much more efficient. You probably have to pay less if you give people directly money, and they'd be very effective. I want to look at one of these which is making political contributions on a person's behalf. So there's this big case about 14, 13 years ago called Citizens United. And the rule after Citizens United is that corporations can't contribute money to individual candidates' campaigns. Although, as we pointed out before, the political action committees can up to a limit, okay? Individuals can contribute, but only up to right now, $3,300 per election per candidate. Corporations and individuals, however, can make unlimited direct expenditures on behalf of candidates and campaigns, provided that that spending is uncoordinated with the campaign of the candidate. So what that means is, though, is that I can't, as a corporation, hand over money directly to you if you're running as your political campaign. But I can, so long as I don't talk directly with you, spend unlimited amounts of money from the corporate treasury, not from the political action committee, but directly from the corporate treasury, running advertisements and things on your behalf, hiring people to go door to door, to convince people to vote for you, that sort of thing. And it's thought that that can be pretty effective. Before, now, post Citizens United, we have so-called super PACs, where corporations and individuals can contribute, meaning they don't have to make the decisions themselves as to how to spend money, not to the candidates and their campaigns directly, but to another entity, the super PAC, which is making those decisions about how to spend money directly. So if I'm someone in a corporation who doesn't feel like I know a lot about politics and want to contribute, say, $100,000 to aid someone's campaign for Congress, I don't typically do it myself, but I give that money to an outfit which is accepting money from a lot of people and corporations for that purpose, and it makes those expenditures. And it's thought that super PACs can wield a lot of influence over the people on whose behalf they're making these expenditures. Also, under the law, it's possible to make these expenditures without there being any kind of disclosure. So it's very technical, so I'll just basically show you how it works. I'm a corporation. I can contribute to what's known as 501c4, which is a certain type of nonprofit corporation. And nonprofits, because they often work in areas of political sensitivity, often don't have to disclose who's contributing to them, because it's thought it could lead to political vendettas and things like that. And then the 501c4 can in turn contribute to a super PAC, which can make ads then on behalf of a particular candidate. So the donors who are making all that money, no one can see that they are contributing to this political campaign. And so that a lot of people believe that that is being abused nowadays. And this is an example of how there's not even disclosure, let alone any kind of prohibition on it. So this is a growing influence. Super PAC spending roughly doubled in the next presidential election from the last one, as it did from the last one, from the one before that. It will equal all spending on lobbying in America. Yeah? And there are many people who say actually that it's, we worry about lobbying, but actually the direct campaign spending is even more worrisome. So think about I want to leave with you the thought that as important as lobbying is, you also have to worry about the larger ecosystem in which it operates. And if you're making direct comparisons, say, between the EU and the United States, you need to compare those parts of the picture as well. That's it. Thank you very much.
Thank you very much, Dan, for this very rich and useful conference. It is very clear the situation in USA. Well, before giving the floor to Roberto, he wrote a book on the regulation of lobbying in USA. But before, I have a reaction. Well, if I try as a professor of lobbying law in Italy, if I would like to do the same presentation that you presented on the Italian system, on the Italian lobbying system, I cannot do. Why? Because it is impossible in Italy to find the information that you provide. We have no idea how many lobbies are working in Italy because doesn't exist a register. It's not possible to find a list of which lobbies finance politics, in which way. It's not possible. So the first reaction is, wow, you have a lot of information. You can Google, you can find, you can also evaluate politicians and other public decision makers according also to the lobbying activity. Because when you vote for a member of the parliament or for the president of the new president of the United States, before voting, you can know who paid for his electoral campaign, which PAC supports the electoral campaign. So which kind of interest the politicians decide to support in the future if in case he will be elected. It's not possible in Italy to have this clear situation. So we vote without basic information. And another reaction is about lobbying and democracy. Because as Dan, as you show us, the issues of the regulation of lobbying is the issues of democracy. Because lobbying, in a right way, in my point of view, influence the democratic process. If you do not have information about this process, there is a problem for the democratic system. So this is the second reaction, but I don't want to spend more time and considering that here there is a great two experts, because there is Roberto and Silvia connected as a discussant. Unfortunately, my colleague Francesco Clementi cannot be part today for health reasons, but Roberto, I give you the floor for your reaction after the DAN conference. Please, Roberto, take the floor.
Thank you very much, Pier Luigi. I hope you can hear me well. And I share the same feelings of Pier Luigi about, listening to a qualified speaker about lobbying, that is a United States citizens. Because as an Italian, I have the same feelings of Pier Luigi about lobbying, because Professor Ortiz can punctually criticize the system of general lobbying regulation in the United States, but we cannot do the same thing in Italy because we have nothing about lobbying regulation. That's why I'd like to draw your attention on the socio-political floor. Pier Luigi knows that from some time now I'm studying the perception of lobbying from the public, in the public opinion, and the conflict between populism and lobbying. So I'd like to share with Professor Ortiz a quick reflection about the socio-political exploitation of lobbying by the press and towards the public opinion, especially regarding the use of the words lobbying, lobbies, and lobbyists. Because in Italy, the lacking of a general regulation that actually defines what such activity and their subjects are, has allowed and still allows the press an improper use of such terms, mostly, in my opinion, to drive the public opinion towards the idea that anything connected to this phenomenon, to lobbying, lobbyists and lobbies, is somehow unfair, especially regarding the correct functioning of the democratic process, if not illegal or even criminal. Some days ago, I read two articles, maybe Pier Luigi remembers them too, about two politicians, Massimo D'Alema and Maurizio Gasparri, which were defined in these articles as lobbyists. I'm not interested in deepening the matter of the activity they were appointed to by the press. The thing that I noticed was that using the term lobbyists to appoint such politicians was a way which the press used to underline the illegal or unfair activity they were carrying out as Italian politicians. And this is, I think, what Pier Luigi underlined as well. Since we don't have a general regulation of lobbying activity, we don't have definitions either of lobbyists or lobbying activity or lobbies, we still don't have the instruments, the tools to define as well what is a legal activity of influencing the democratic process or influence the democratic decision maker or not. So my first question is if Professor Ortiz thinks that the provision of a general regulation of lobbying may truly affect the perception that the public opinion has of this phenomenon. What I'm asking you is if you think that in the United States, since 1946, the regulation, the general regulation of lobbying activity has somehow influenced the public opinion, because we know that lobbying is an issue in the United States as well in the perception of the public opinion. But the general regulation of lobbying, I think, has helped the United States citizens to know well what was lobbying, what are the lobbying activities, what is, who is a lobbyist, in a way related to the transparency of the political process, of the democratic political process. As Pier Luigi said, lobbying is an issue of a democratic and pluralist system. So what I'd like to know is if Professor Ortiz thinks that the presence of a general regulation of lobbying activity is somehow a plus for the public opinion to better understand the correct functioning of the democratic process.
Sorry. I certainly agree with you that transparency is very important to any democratic system. And the laws here have certainly improved transparency. Before 1946, it was basically opaque, and people knew little about who was influencing whom, how much was being spent over what kinds of issues. And now there is a window into that, and that is all a positive and very healthy for democracy, I think. On the other hand, and just in terms of public and political perception, the law has worked at times to decrease the most troubling aspects of it. So, for example, direct gifts to people in Congress, travel bonanzas, things like that. Things that when people became aware of them through the press, but largely before, came at a very high political price to the people involved. Now, that kind of stuff doesn't happen. And so you have fewer, in a sense, scandals about it. because regulation has done that. But as I say, it may just have pushed some means of influence into other kinds of modes, like campaign spending and things like that, where people really can't see them very well, where people can basically make contributions to, say, a super PAC without any kind of disclosure at all, which in turn can influence potentially a person running for Congress a lot. So in some ways, it really has helped things. And I don't, by criticizing the American system, I don't mean to suggest that everything is bad and that the situation is worse now than it was before. But I just want to point out that in some ways, the regulation is a mixed bag. And you might suspect that the point of some of the regulation is maybe not to provide transparency so much as to stop the politicians from harming themselves by being in the position of perhaps wanting to accept a gift that they know they really shouldn't accept, or go off on a very expensive trip to a very exotic place when they know they shouldn't do that, and then they're caught by it. So in some odd ways, it has, on the one hand, I think, increased people's trust in some American institutions because they feel that they can see into them better, see who's influencing them, what's going on, and that is good. On the other hand, it has made things a little bit harder as well. And so it's a very complicated picture.
Sorry, Roberto.
Yeah.
Yes, take the floor, you, and after I have another question. Please, Roberto.
I'd like to ask Professor Ortiz as well if he sees a link between the populism and lobbyism. If lobbyism may be considered as a tool to decrease the political populism that is spreading worldwide. If the transparency that is related to the general regulation of lobbying activities can be somehow a tool, a political tool to contain, to reduce the widespreading phenomenon of populism.
In theory, I believe it could. Whether it does so in practice or not, I think is a very different story. So if you view lobbying as allowing information, especially certain types of technical information, to get to political decision makers that might not otherwise get to them, that of course could work as a kind of break against some populist policies that might actually be misconceived. They may be politically popular, but substantively bad for various reasons, either economically or scientifically, whatever. But on the other hand, it's although populists, at least in America, you hear campaign slogans like "We will drain the swamp" in Washington, and the swamp, as broadly conceived, is this vast conspiracy that runs from very powerful economic and business interests on the one hand to people who are entrenched in political, not political, but employees in the executive branch who have their own interests at heart rather than responding to the interest of either Congress, the president, or the people at large. So to a certain degree, is that one of the cries you certainly hear from populists is that that kind of influence is very bad, and that is what populism aims to extinguish. On the other hand, we practically look at the people who are funding populist movements in America, at least at this point. They are often people who are not purely ideological, but often represent interests of big energy companies. On the one hand, the Koch Industries is one very famous one that contributes to a lot of sort of quasi-populist organizations on the Republican side in America. So the funders actually don't appear to be all that different. It's just that you find and the idea, I believe, is that these business interests think that if they can get populists into power, they can then co-opt the populist themselves. And in fact, they have the populist even beforehand campaigning against things like climate change. So in America, for example, most of the populists are climate change deniers, in fact. And that is in turn partially funded by or supported by big oil companies and big energy companies. So it's really just a different kind of mechanism and chain of influence, I think, that's working there. But certainly it can. In theory, you would hope that it would. But populism can be co-opted by some of these exact same players as well.
Well, thank you, Dan. I don't know, Roberto, if you want to add something or you want to come back after, because I have other two questions, but at the same time, I would like to tell to our students that are online, students and experts that are online, if you want to put any question to Professor Ortiz, you can write in chat. We can read from the chat, and then Professor Ortiz, can reply to you. But I have two questions for you. One of these is very big. So, well, the first one is, you presented the regulation in U.S.A., but according to your opinion, are there any loopholes? Which are the loopholes of the regulation that you presented? Because also, for example, I remember the Abramov scandals. Mm-hmm. No? It was a scandal in USA, but in Italy it was normal because it was normal because Abramov was considered an enemy of the democracy because he paid a ticket for the football match, the baseball match, right. The leader of the Republican Party. This is normal in Italy that you lobbyists pay for this, and nobody care about. But apart of this joke, so which are the loopholes on this regulatory system according to your opinion? And a second issue is about the revolving door. So we know very well that several times happens that lobbyists began member of the government, and former member of the government, after 1, 2, 3 years, come back in the lobbying system as a lobbyist. In Europe, we don't have, in Italy, we don't have a rules on the revolving door. In USA there are. So which are your opinion about the revolving door system and the situation in USA?
So if there are any, first let me speak to the loopholes. The Abramov scandal was a great one, and it was what was responsible for the enactment of the gift and travel rules in the late 1990s. Yeah. So it was directly responsive to that. So what you notice, I mean, there's this common picture. You have a set of rules. They don't cover everything or everything well enough. So there are some scandals. Congress reacts to those scandals. So those old scandals won't happen again, or if they happen, they'll be punished, and people will feel better about them. But that doesn't relieve any of the pressure that was originally responsible for people giving baseball tickets to people or sending them on wonderful trips. So that same pressure is there. Yes. Yeah. So that same pressure is there. It's just going to manifest itself somewhat differently. So the real problems now, I think, are not so much within the lobbying system itself. Mm-hmm. This is why I said you have to picture lobbying, think of lobbying as just a part of the larger ecosystem of influence. The major problems are elsewhere in the picture. So corporations, people who want to lobby, participating in politics in this way of giving huge amounts of money to political campaigns through super PACs. That's a real worry to my mind. The Supreme Court has recently, over the last 15 years or so, in a series of decisions, weakened some of the laws, criminal laws, surrounding other means of influence. So there's a statute called the Honest Services Statute. And you can be convicted of honest services fraud if you're a government official and you corruptly commit an official act because of some, say, watch you received. So in Virginia, there's a very famous case where we had a governor named McDonald who received a watch from someone who was trying to sell fake drugs. I mean, herbal remedies, things like that. And he wanted access to all these state decision makers who had power over how he could market them, what he had to say, labeling, and that kind of stuff. And in response to giving the governor a watch, it was alleged, and allowing the governor's wife some gifts, and allowing the governor to drive a very fancy car for some period of time, the governor opened doors within the government where he told these people, you basically should speak to so-and-so, you should listen to this person, and exerted some form of pressure on them. But was very careful not to say you have to make this decision and you have to favor him. But surprise, surprise, those officials ended up doing that. And the federal government prosecuted the governor for honest services fraud, saying, you aren't supposed to make official decisions this way, and you aren't supposed to exercise pressure this way. And it went up to the Supreme Court, and the Supreme Court said, no, we're going to pull back on what counts as corruption here and what kind of government act has to be involved. So merely giving someone access to the decision, special access to the decision maker, saying they should carefully listen to what the decision, the person wants to say, doesn't constitute necessarily fraud. So they've been cutting back on that, which of course has had the effect of encouraging people to do things more that way than through lobbying or something else. So to my mind, my personal opinion right now is that the real problems are around or occur in other parts of the ecosystem. Campaign finance law, honest services fraud, bribery law has been brought back. We now have a U.S. senator who has been charged with accepting, I believe it's $500,000 from someone, along with 2 gold bars, a car, a Mercedes convertible for his wife, a job for his wife, which entails no work. It's like all those other, that list of things, like practically every one of them is involved. Senator Menendez from New Jersey. And, he's saying, no problem, with it. And that's, but, it looks like there may be a strong criminal case, but we'll see.
Perfect.
But that only answered half of your question. I think there was another part.
A revolving door.
Oh, the revolving door. So, the revolving door, we have revolving door bars, both in the executive branch and in Congress. What usually happens, though, especially for very high-level actors, is that they will be taken care of for a period of 2 years. So you're not allowed to lobby on the interests of anyone in an area where they worked before, but they can work as a lawyer in general, or they can lobby on behalf of other interests if they want. So it helps a little by decreasing the efficiency, if you will, of lobbying. Because if you can't lobby on the particular issues that you were in charge of before, well, people will take your opinion seriously, but maybe not as seriously as they would have otherwise. Again, that's only for a period of time.
Thank you very much. I don't know if there are any questions also from the floor.
I do. Okay.
Present yourself.
Sure. My name is Enrico Campelli. I'm from Rome, from University La Sapienza. I'm teaching also comparative constitutional law and LUMSA. So I do have a question for you. First of all, thank you so much. This was very interesting for me. I would start by saying that I strongly agree with Professor Petrillo when he says that regulating lobbies is actually an issue of democracy. And I'm particularly interested in what you said about the ambivalence of lobbies that inform but also deform. So it's undeniable that lobbies, at least in the European or Italian context, have certain negative connotations. So my first question is, would you consider the lobbying process of democracy something irreversible? And if yes, is that possible or enough to regulate it? Or we need some kind of cultural dimension in changing this paradigm? And my second question is slightly technical. I was very surprised when you said that to be defined a lobbyist, you need to spend 20% of your professional time in doing so. Isn't that very broad? Very, 20% is not that much. And also, but the report, the forms that you show us, seems very agile. I mean, very light. No, I would expect something more. I mean, I'm from Italy. Bureaucracy here, it's huge. That report that you show us seems very agile. I was quite surprised. So this is my question, first of all, about the irreversibility of this process and if that regulating is really possible or enough, or maybe we need a cultural dimension. And this second technical question, 20%, again, seems really broad, really simple, really not that much. Thank you.
I think both of those observations are correct. As to the cultural dimension, I think there always has been a cultural dimension here, and has changed, at least in America, and has changed over time. 200 years ago, lobbying was viewed mostly through the lens of individuals lobbying government for their own individual interests. And that was strongly viewed as a democratic right. Any American should have the right to speak to Congress. And in fact, there was a committee, I believe there was a committee in Congress eventually that was set up just to handle these kinds of things. And so, you know, that's something that people went to war against Britain with, and it was written into the Declaration of Independence that was one of the reasons for the war. The king had not actually listened to what was going on. So, I mean, so in America, there's a strong cultural resonance there. On the other hand, ever since the end of the 19th century, the progressive movement, which is quasi-populist, but not completely, there's been a lot of distrust as lobbying has become more professionalized and has come to represent more big interest rather than individual people. And so people are a little bit suspicious about that. I believe that they think it's inevitable. Of course, you want people, even big corporation, to be able to bring legitimate concerns to the people who are making decisions in government. That's important. But on the other hand, the worry is maybe they're going to be bringing misinformation rather than information because they are interested primarily in just feathering their own nests. Or even if they are bringing real information, correct and accurate information, that's going to somehow drown out and for accurate information coming from other less concentrated groups. And that's an independent democratic concern. And of course it is. And there's a tension there that's not resolvable. It's always going to be there. There's no way around it. I think most places like the EU and America thought that the best way to negotiate the balance is through disclosure of most things and bans of just some things that are most troublesome, like gifts, bribes, travel, that sort of thing. Now, part of the cultural view towards lobbying happens in culture largely independent of the laws. It's just people looking at what's going on. And when there's a very bad scandal, you see someone paying someone, for example, in the Menendez case, allegedly. Well, people are going to have a reaction to that. I don't believe that a strong cultural suspicion of lobbying would be enough to sort of take care of the problem, if you will. But of course, if the people, the voters, are more worried individually and collectively about lobbying, politicians who are running for office are going to realize that that's a more important thing for them to worry about, or at least the appearances of it are, and will presumably incorporate that into their behavior. So it can do some work. I don't see it doing as much work as the law itself does now. And of course, to people's minds, when they think of lobbying, whether as a good or an evil, they are thinking of it discreetly, individually, as one particular activity, and they don't see it as part of this larger ecosystem. And not seeing that, I think, is a problem.
Okay, thank you very much. I don't know if there are other, Tiago, please. You can take the floor from there, yeah. I think
Just need to...
you need to see it, perfect. And then Roberto, thanks.
First of all, thank you for your brilliant conference. And I would like to ask you, how hard is it to enforce this regulation in the U.S.? What are the main difficulties to enforce these all these complex regulations?
So the enforcement difficulties come in two parts. First, there's understaffing. So this is run mostly, especially on the legislative side, by the Office of the Clerk of the House of Representatives and the Office of the Secretary of the Senate. And those people do a lot of other things, which are the people in Congress view of more concern. They are just understaffed in general. So the GA, the Government Accounting Office, has been tasked with doing random audits of these forms, but a very small number of them. Typically, this is low on the list of what happens within these offices themselves. They don't really do random audits. If something really obvious is wrong, if someone has said that, has registered as a lobbyist and then filed no reporting forms for a period of time, they might get back to the lobbyist saying, are you really doing this? If not, you should terminate the initial registration, that kind of thing. But it's not as if they're going back to, say, the lobbying firm and saying, let us look at your expenses. Is this really how much money you spent? And were you really lobbying on exactly these issues that you claim? Maybe that's very difficult, time-consuming and very intrusive. So much of that less relies on self-disclosure. Then, of course, when something happens, it goes to the U.S. Attorney's Office, and that's a sort of local branch of the Department of Justice. And among crimes, federal crimes, that's federal, it's important, but it's pretty low on the list, given all the things, people killing each other and other things that they have to worry about. So it tends to be under-prosecuted, and you have to, for a criminal conviction, you typically have to prove a very high specific mental intent, that it was done with a corrupt intent. And it's not quite clear what that word means and how bad your motivation had to be for it. So there's some legal uncertainty there as well. But mostly it's just a question of resources.
Thank you very much, Roberto.
Yes, sorry if I take again the floor, but something that Enrico Campelli, if I recall well, if not, I apologize.
Yes.
Okay. Something that Enrico Campelli said drove me to another consideration. Among the many interesting things that Professor Ortiz said, I was hit by the difference between lobbying parliament and lobbying government, especially the part regarding what I intended as some kind of inverse proportionality between legislative and executive branch regarding the subjects either covered or uncovered by the general regulation of lobbying. Because in such a matter, I think the United States and the European Union government are much more alike than the Italian one. My idea is that when we in Italy think of lobbying activity and lobbying pressure, we are naturally focused on parliament and not government. The only regulation we have in Italy about lobbying, Pier Luigi knows it, is a very agile, very tiny regulation in Chamber of Deputies regarding the activity of lobbyists by the Chamber of Deputies. So my question is, if Professor Ortiz thinks that regulating lobbying is also a matter from a constitutional point of view, is also a matter of a form of government. If regulating lobbying may vary in order to different type of government. If there are some general rules that can be applied to any kind of government, but other than that, if the regulation of lobbying activity should be focused on the different kind of government that applies it. Because again, I can see many differences between the United States and EU type of government that are somehow alike, and the Italian one that is very different.
Dan?
That's a very good question. So when it comes to very high-level policymakers in the executive branch, typically the rules or the regulatory scheme is structurally similar. There's very big difference, though, in the amount of people who are covered. Where things start to look different, though, is when you get to the administrative agencies, where a lot of policy is made. And there, the concerns are handled a little bit differently. So, for example, most agencies now do make a lot of policy through so-called rulemaking, where they will announce beforehand that they are thinking of regulating in an area and what their preliminary intuitions are about how they will regulate in the area. And then they'll publish that in the Federal Register, and they will leave a certain amount of time for people to comment on it. And historically, the comments where people would send in pieces of paper, letters, things like that to the agency, and there would be a public docket that would be available where everyone could look to sort of see what everyone else had said. And it was viewed that the contacts made to the agency about the policy should come in through that window, if you will. Nowadays, it's all on the internet. And so people send in comments. I can see immediately what everyone else is saying. I can submit another comment. And then after the commenting window closes, the agency goes back and evaluates all the comments and formulates the final policy. Now, if people contact the agency outside of that mechanism, the agency has no duty to respond to them, and its policy cannot be judged by whatever their concern was. So if I'm a lobbyist and I want to point out something to the agency that's very important in making the policy, I am not going to be inclined to contact the agency decision makers directly and individually. I'm going to be inclined to send a comment through the public record mechanism, because only that way does the agency have a duty, in a sense, to respond to me. And if I raise a comment and the ultimate agency decision is badly unresponsive to that comment, meaning they just ignore it, but anyone, especially a judge who will be evaluating the policy after it is announced by the agency when it comes under judicial attack, the agency can say, listen, that public comment wasn't in the record. You cannot consider it in judging the substantive validity of the policy we basically promulgated. So someone who's lobbying and would actually want the comment or the contact to be visible to the world at large from the beginning. Otherwise, it would have no weight, no real weight before the agency. So it's not so much of concern in that part of government. It's thought to be a little bit self-regulating, since the person who makes a secret, if you will, secret comment can't later use the information in that comment to substantively attack the regulation in court when they're seeking judicial review of it. So if it sort of forces all that to be made on the public record where everyone can see it right from the beginning. And so it's sort of, it happens, that's how the regulation happens. And it's thought to be pretty effective.
Thank you very much, Dan. I know that there is a question from the audience, but I have another question to you. You teach at the University of Virginia, you teach ethical values. And it is clear, according to your presentation, to the news that we have, that in the United States, the strongest lobby are the richest. So there is any ethical aspect about this, or the rules that was introduced give the same opportunity for the whole lobby, give the same rights. So the economical aspect, the money, are not so relevant for the lobby, or there are unethical issues about this.
Well, there are lots of ethical issues surrounding lobbying. In fact, there's an ethical code around lobbying, and that is pretty much self-policing. The sense that it has real teeth, it's because future potential clients will avoid you if you're a lobbyist, if you've been seen to act unethically in a bad way in the past. And so lobbyists will tend to abide by the code, knowing that if they are seen to violate it, it will be bad for business in the future. And of course, many lobbyists have very deeply centered ethical commitments that would prevent them from doing some things. But often, it's unclear whether a particular action falls. Now, the real question is there are lots of organizations which lobby on behalf of corporations. There are very few relatively few that lobby on behalf of individuals. But there are some, and they often will lobby around particular kinds of social interests. There are some more general groups like the Good Lobby in the EU, run by Professor Alemanno, an Italian working in France, who's very interested in these kinds of things. But it's generally thought that they are underfunded, outnumbered, don't have much of a voice, but they are there.
And the regulations cannot resolve this problem.
No.
Tiago, if you can read the questions that we received online.
So we received a question from Professor Serena Leoni. She precises that as in the US, you have a different form of government than Italy. She has a question on the relationship between lobbies and the president. So does the change of president influence lobbying activities? And how does lobbying change when the president changes?
Yes to the first question, just as it does in Congress. Whenever control changes from one party to another, lobbying firms will be quick to try to hire people who worked in past administrations of that party, thinking that those people will have more of a voice with the people who are there now. Same with control of Congress. If Congress or one house of Congress changes from one party to another, different people will take some of those positions. Now, of course, this refers primarily or affects primarily those people in what I call the spearhead positions, the people actually reaching out and making the contacts, not the huge army of people behind them who do the research, crunch the numbers, do all the important real work, but don't make the individual contact. So it depends upon where you're located in the lobbying industry. And sorry, there's a second question.
How does lobbying change when?
Okay, so when the president changes, the personnel change. You want people from different parties who have different kinds of contacts inside the administration. So a lot of that changes. The kind of policies people will be lobbying on will change. So, for example, in a Democratic administration, the people who are lobbying around the issue of climate change are very different along the executive branch typically than they would be during a Republican administration. You would have environmentalists more and less of the energy interest, if you will. So that changes. The techniques don't really change so much. Some interests will engage more in so-called grassroots lobbying, where they will lobby directly, but then they will also lobby to change public opinion so that people will then write the president or write the people in Congress saying, it's very important that you take this position on policy, that kind of thing.
Okay, so thank you very much, Dan. It was a very useful conference, and also because you spent more than 3 hours discussing with us about this topic. It is clear that in the democratic systems where there is a strong state presence in the economy, there is also a strong lobbying activities. We can say that more state, more lobbying, because it is close. And also it was clear, thanks to your conference, how it is important to regulate the lobbying activity if you want that democracy works well. Because without any regulations, without any transparent system, it's impossible also to evaluate, to account the public decision makers, and not only politicians, but also all public decision makers. So thank you very much again, Dan.
Thank you
for being here with us. And thank you very much to our colleagues. Thank you very much, Roberto. We hope that the next seminar we can be all together in person. And that's all. Thanks again.
Thank you.
Grazie.
Thank you all.
Grazie mille. Grazie. Davide, grazie mille.